Mr. Bender.
May it please the court. Chief Justice Katie and fellow justices, good morning. My name is Bradley Bender. I represent Mr. Cordero. I apologize in advance if my throat begins to scratch or if I begin to lose it. I've been battling strep for the last several days. The primary focus of our application for further review is on the jury instruction that was not given regarding the intoxication defense. The Court of Appeals ruled that the instruction should have been given, however, Mr. Cordero was not prejudiced. We are in agreement with the Court of Appeals that the instruction should have been given, but we disagree with their conclusion that Mr. Cordero was not prejudiced. First off, Mr. Cordero acknowledges that no notice of the intoxication defense was filed by his trial counsel. Under Rule 211, as the Court of Appeals states, that does not forbid him to seek the instruction if the evidence does allow it. I think there's no dispute here that both the state and the defense attorneys in both parties during the trial introduced evidence of Mr. Cordero's intoxication. There was exhibits admitted by the state with respect to what was found in Mr. Cordero's truck, which shows empty beer cans. And I believe almost every witness who witnessed the shooting at the automobile shop testified to some extent on their drinking behavior, Mr. Cordero's drinking behavior, and also Mr. Miguel's drinking behavior. So we do meet the threshold.
Counsel, would you agree, though, that to be entitled to the instruction, you have to show more than mere intoxication, but rather evidence that a jury could find the defendant was so drunk he couldn't form the specific intent to kill someone?
Well, I think in order to get an instruction, there must be a threshold that needs to be met, and that is a substantial evidence of intoxication. And that's what the Court of Appeals ruled, that there was substantial evidence, albeit not overwhelming, but there is enough evidence in the record to show that Mr. Cordero was drunk. We have testimony from the state witnesses that Mr. Cordero showed up at a buddy's automobile shop before 11 a.m. that morning. He stated he was drinking. They went out and bought beer, and they were drinking all afternoon. Then he shows up at Miguel's automobile shop after 4 p.m. that day, and the state's witnesses, albeit their versions were different, it was pretty consistent that as Mr. Cordero came in there the first time, he grabbed a beer and he was drinking. And if you look at the state's exhibits that they were submitted, that it shows that there was empty beer cans found in Mr. Cordero's truck that was impounded. So we feel that under the standard that this court has put forward, excuse me, Your Honor, with request to where we can request the jury instruction, there is substantial evidence of Mr. Cordero's intoxication.
Do you need to have expert testimony to get into the whole idea of whether, in their opinion, they had the mental capacity because of the intoxication to form the requisite specific intent in this matter? Do you need to have any type of evidence like that?
Not in every case you have to have that, Your Honor. And I think
in a case like this where it's fairly disputed, isn't that something that would be?
Well, I think the case that the Court of Appeals relied on, the Broughton case, there was no expert testimony in that case. And they specifically stated that the intoxication defense should have been given. And that was an interesting case because that talked about whether there was an alibi defense and intoxication defense can be given at the same time because they're mutually, they're not mutually exclusive of one another. And in that case, the evidence was not that overwhelming of the defense intoxication. It was just based on his testimony and his buddy's testimony that he was intoxicated. Now, I think in this case here, because you didn't file the notice of intoxication defense, if the defense was trying to put on an expert, the court probably had in its discretion to exclude that. But what we're talking about here is the court did not exclude none of the intoxication evidence. It allowed this evidence to keep coming in. And then when the defense counsel stands up and asks for the intoxication defense, it says no. The defense attorney then goes in and gives a closing argument, and the state never objected to the defense attorney arguing intoxication during the closing argument. And then, so therefore, we feel we met the threshold to request the jury instruction. It was allowed for by the evidence. Both parties submitted evidence on it. And then here we go to the prejudice element.
Before you get to prejudice, is it your position that any time there's evidence the defendant had been drinking, that the court must give intoxication instruction if requested?
Well, under 211, it says that a defendant can stand up and testify at his own trial regarding his intoxication, and the rule is not limited by the failure to give the intoxication defense. So if Mr. Cordero...
If I may follow up, that's
Sure.
not quite the question. If there was merely evidence that one beer was consumed, let's just say that the record was not disputed, one beer was consumed, I take it that would not be enough to get an intoxication defense.
Well, I agree with you on that.
Right.
I believe
So,
that there
all right,
has
so-
to be
well-
there has to be some evidence of more than just casual consumption. I think if you have someone who, if we play in hypothetical, if you're talking about someone going out, having dinner, they had one alcohol, and then they killed someone, it's going to be hard to argue that for intoxication defense. But that's not what the evidence, this record supports.
So your view is the Martinez statement, even though there are 4 witnesses who said he'd been having beer during the day, but he wasn't drunk. The Martinez statement that he was probably drunk, that's enough to get you the instruction.
Well, I think it's the accumulation of all the evidence. We have, Regello, Bersurdo, who testified that they were drinking all day. You had the fact that he was drinking when he showed up at Manuel's and Miguel's auto body shop. You have the other witnesses of the shooting who stated that, who were there before, who interacted with Mr. Cordero, who said, the one, Mr. Martinez, said he appeared to be drunk. And then also what the state introduced, which was his vehicle that was impounded shortly after this incident, to show that there's empty beer cans in the...
That's hard to see the photo. It looks like maybe 3 cans, but there's no proof when those were put there or where they came from or anything like that, right?
No, but I think if I don't think no one's disputing that everyone involved was having a good time that day because it was 4th of July. There's no dispute that they were all drinking to some extent. And I think, given that as the evidence that came in, that, there is evidence of Mr. Cordero's intoxication here. And that this court has stated that intoxication can negate the state of the mind for murder in the first degree.
Mr. Bender, I think we can all agree that there was some evidence of some intoxication. Mm-hmm. One witness testified that he was intoxicated. Others said that he'd had some beer. But was there any evidence in the trial that the intoxication caused any mental disability that made him incapable of forming any specific intent?
Well, I think it's the evidence. What we looked at is that the state introduced evidence of prior intoxication of Mr. Cordero, where he previously showed up at this auto body shop drunk, and he would exhibit erratic behavior, damaging their cars or getting into arguments with Manuel or Miguel. So therefore, I do think that by the state introducing that to show that when he was intoxicated, Mr. Cordero on previous occasion has exhibited erratic behavior. On this occasion, he was intoxicated. One can assume that he was exhibiting erratic behavior, and therefore he did have that mental incapacity to form the specific intent.
Do you agree that evidence of intoxication is not enough to meet this defense?
I agree with that, Your Honor.
Okay, and so would you agree that the evidence of intoxication has to show that the intoxication caused a mental disability that made it incapable for the person to form in specific intent?
Yes, Your Honor.
And I would think that in some cases, if someone is just falling down, stumbling, drunk, a lay witness could, if that's what we were witnessing in this room, that we might be able to conclude as lay people that the person wouldn't have the capability to form a specific intent. What was it about the evidence in this case that would allow this jury to take the limited evidence of intoxication and transform it into a finding that the defendant didn't have this specific intent?
Well, I think this kind of goes to the prejudice element that we are alleging here, because what happened here is that the district court has allowed both parties to introduce this evidence. Then they allowed the defense attorney to give their closing argument as they did, which was talking about how this intoxication, they were so intoxicated and that they could not form the necessary intent. What happened here is that the jury was not instructed how to use this evidence. They were not instructed to look for that specific idea. Did it cause a mental incapacity? And, this court has regularly stated that, if we confuse or mislead juries and jury instructions, that we are to, reverse and send back. It should be saying likewise. If we fail to give a jury instruction and it confuses or misleads juries, then we should likewise reverse and send the case back. And to speak to your question specifically, Chief Justice, the fact that the jury was not instructed in how to look at this intoxication evidence, they failed to make the determination which they're required to do. Did the intoxication undermine the specific intent? They would have been instructed to look at, was all this evidence cause some type of mental incapacity? They didn't have to make that determination here. And the evidence that was presented allowed for this instruction to be given. If the Broughton case allowed in based on just the testimony of his buddies and his testimony alone, given the evidence that was presented here, the instruction should have been given. And for the Court of Appeals to rely on the fact that trial counsel tracked the jury instruction in their closing argument is to no avail to overcome the prejudice that was already presumed in this case.
It seemed like the trial judge in this case did, when presented with this issue at trial, did spend some time with it. And I think it said in the transcript that over the lunch hour, he went through and reviewed the evidence of the witnesses. And is the most critical point in this analysis is it's not the fact that there was evidence of drinking and intoxication, but of the lack of evidence of what that drinking or intoxication was doing to his ability to function? Was there any evidence that he was incapable of or struggled to perform tasks or couldn't walk or had, and the county attorney argued that he shot the gun pretty well, and he looked at other evidence where would show that he may not have had any mental disability.
It is true that one would, I think this goes to the fact that, we can never make the motion to change the facts that we are presented here, and we were dealt with the cards we're given. Of course, I would love to have those other questions asked of those witnesses, the fact that, what exactly was his behavior? How was he acting? What was he exhibiting? Was he sweating? Was he able to slur in his speech? Was he off balance? We don't have all those factors in this case. But we do have is the timeline of what he was occurring that day, his behavior that he was exhibiting that day, the statements he was making that day. And one can argue the behavior that he exhibited to carry out this incident is could be viewed due to his intoxication, because the Court of Appeals grasped hold of some statements that Mr. Cordero made a couple of days before that. Boy, I was gonna I would shoot Miguel, but I chose not to because he's family. One can say the intoxication caused him not to be, to go ahead and overcome that prohibition and to shoot him. So therefore, we do feel that the intoxication was important. The jury, by not being instructed,
That's not the test, is it? The test is not, does the drinking kind of lower your inhibitions? The test is, I think like the chief said, that the intoxication is a defense only when it causes a mental disability, which makes the person incapable of forming the specific intent. Where is the evidence in the record that he had that level of a mental disability? Seems like there's a lot of evidence that this was, that he had the intent to do what he did do.
Well, we would disagree that it would show that there's overwhelming evidence that shows the intent that he was going to do what he was going to do. I mean, we do acknowledge and we don't dispute that he had a gun. Trial counsel did not dispute that, and we don't dispute that on appeal. But that alone does not mean that, he was intending to shoot Miguel. I mean, even a couple of days before, despite the Court of Appeals relying on the statement, he stated he wanted to shoot him, but he wasn't going to because he's family. And that shows right there that, they're trying to use that statement to show that he had intent, which we are saying that it doesn't really show that he had intent, because if he really wanted to kill him, he would have went in and carried it out at that previous time. But if you look at the intoxication, I know my time's over here, but if you look at each of the witnesses, and we ask that you do, that if you look at their testimony, we do believe there's enough evidence, because the threshold is not beyond a reasonable doubt whether he was intoxicated or not, is whether or not there's substantial evidence in the record to support giving that jury instruction, which therefore the jury will be instructed. And we do feel we met that threshold. And I think the Court of Appeals was correct on that, but they were incorrect on their ruling that there was no prejudice.
Thank you, counsel. Mr. Hanson.
Good morning, may it please the court. One of the trial court's gatekeeper functions is to make sure the jury reaches its verdicts based on the facts, not on speculation. It does so by requiring substantial evidence to support the charges to overcome a motion for judgment of acquittal, and it does so by applying a substantial evidence standard when deciding whether to give affirmative defense instructions. In this case, the evidence did not merit an intoxication instruction. First, there's very scant evidence that Mr. Cordero was intoxicated.
Well, he was drinking all day, apparently. He was drinking in the morning, he was drinking in the afternoon. He was drinking in the morning before 11 o'clock. He was drinking when he was at the first body shop, and he was drinking at the second body shop. Looks like an all-day drinking episode, does it not?
But drinking beer is not the same thing as being intoxicated.
Well,
he could have been sipping on a beer all
Sure.
day.
But what can a reasonable jury conclude if you started drinking in the morning and was drinking all day and has cans of beer, albeit maybe 3 or I don't know what, for sure, in his car? Could a reasonable jury conclude that this was a drinking fest?
I don't think there's enough to prove that he's intoxicated. I agree that he was drinking all day, but not that he was intoxicated. And especially,
Is there evidence in the record that he's an alcoholic?
there's no evidence of that in the record. Really, the Court of Appeals finds this kind of propensity inference that because he had shown up to the shop in the past drunk, that maybe he was drunk this time. I know the court is not particularly receptive to propensity evidence when it comes to 404B. There's nothing in this record to show that he had a habit of showing up there.
What is the threshold test? I mean, I think it's clear, and I frankly think there's agreement on this, that you have to reach a certain threshold of evidence. I mean, drinking a beer at night, I think defense counsel concedes wouldn't be adequate to get the instruction. How high do you have to get to, what kind of evidentiary showing, in your view, has to be made, to trigger the instruction? And then kind of a footnote, do you need expert testimony or can you do it based on?
Okay, I see that there's 3 levels potentially in this case. First level would be just mere drinking, and that's what most of the witness testified to, that he had been drinking beer. He came to the shop, drank 2 beers. The photo in the record, there's an unopened beer can on the driver's side, there's an open can on the passenger side, and then there's a circle in the floorboard on the passenger side. And I can't tell that it's a beer can. Assuming it's a beer can, I don't know. So that's the first level, just drinking. That's not sufficient. The next level is intoxication. And that's where we have very scant evidence of intoxication. We have one witness who says he was probably drunk. I mean, he's just making an assumption. He was probably drunk, but he doesn't explain anything about why he reached that opinion. And then we have 4 witnesses who say he was not intoxicated. And particularly the witness by the name of Basurto, who's with the defendant most of the day, at the other auto body shop says, yeah, we were drinking, but he wasn't drunk, and he had control of himself. He wasn't, he was speaking okay, he knew what he was doing. So I would say, if anyone, he's in the best position to judge intoxication.
Okay, but counsel, you know, when we're deciding whether to give jury instructions, we don't, the standard isn't, well, there are 4 witnesses who cast doubt on whether he was intoxicated and one that said he was. And I know you know that, but that's a key point. My question is kind of related to that. And in the area of intoxication, we allow lay witnesses to testify about that all the time.
Mm-hmm.
And the reason we do, I think you'll agree, is that that's sort of a matter of common knowledge. You know, there's enough of it that we kind of know it when we see it. Why is there a need in this case to get an instruction for something more than the one witness who says, I think he's drunk?
And I'll answer your question by finishing Justice Apple's question. There's the third level that we have to get to in order to merit an instruction on intoxication, and that's connecting the intoxication to the inability to form specific intent. And in this case, there's nothing to support that final step that's required to get the instruction.
Why isn't that a matter of a common lay understanding? I mean, we know when we see somebody that's drunk, and we know when we look at them, we make a judgment about whether they're so drunk that they're not functioning in their regular capacity, right?
And I agree that could be sufficient in some cases where somebody does come in and say he was so drunk he didn't know what he was doing. He was so drunk he was falling over. He was so drunk that he was, blacked out for part of the day. And that's more like what the Broughton case was. And although the opinion is a little sparse on the degree of intoxication, there was testimony from the defendant and from another witness about the defendant being drunk. Here, there's no evidence that he was really drunk. So in the right case, a lay witness opinion that he was so drunk that he couldn't form specific intent, or
What
a
do
defendant's
you make of
testimony.
the evidence that a week or some period of time before the shooting, he said that he would kill or shoot the victim if he wasn't family? Does that indicate that he didn't have that he would have had the specific intent under normal conditions? How do you analyze that evidence?
Your Honor, the only thing that proves is that a week before he didn't have the specific intent to kill the victim in this case. And the situation has escalated since then. Particularly on this day, they have an argument in the shop. The defendant wants to hang out at the shop with everybody else and celebrate the 4th of July. And the victim says, no, you have to leave because you owe us money. And they have an argument, there's some threats exchanged, some insults exchanged. So at that point, he's angry, more angry than he was a week before. So the fact that a week ago he didn't have the specific intent doesn't mean that it was only alcohol consumption that put him over the edge.
The one witness who said he was probably drunk also testify that when Cordero returned to this auto shop, he first said, I'm going to kill you, to Miguel, who was sitting there, and then fired the gun at him?
That's a very unique peculiarity with the evidence, where the only witness supporting the intoxication defense is the one who gives the clearest evidence on the defendant's specific intent at the time of the shooting.
The error preservation situation. Now, there wasn't the advance notice given of the intoxication defense. Correct. Then, during the instruction conference, as I read the record, the state initially doesn't complain about that fact. The only issue before Judge Rosenberg, I think, initially is there substantial evidence to warrant the giving of the instruction? And he decides not to give it on that basis. Right? Is that your understanding of the record? So it's really not we don't really have a waiver issue of some kind. Then after lunch, he comes back and he's looked at it more and there's further discussion. And that's the first time that the state sort of raises the lack of notice. But it still seems to me that the district court ultimately went on the failure to meet the evidentiary burden rather than the lack of notice. Is that right?
That's my recollection.
So then, if that's the case, then we have to agree with you or find harmless error or something like that. We're not in Strickland territory, right?
Right. My preservation argument. There's a chain of events in a normal affirmative defense that have to happen in a sequence. First is giving the notice, and if you give the notice, then you get to present evidence at trial to support your defense. If you support your defense with substantial evidence at trial, then you get the instruction. And he didn't meet the first step of it. The second step, if you look at the evidence of drinking and intoxication, almost all of it is the state's evidence, and I can't imagine the county attorney was trying to support an intoxication defense for the defendant in this case.
Let me ask this question, as we're clearing out some underbrush here. You know, the Court of Appeals basically says, well, instruction should have been given, but there's no prejudice. It strikes me as a little odd, frankly. I mean, and I understand you're challenging the question whether the instruction should have been given, but if there was substantial evidence to give the instruction, do you agree that the defendant's been prejudiced by his inability to refer the court's instruction and making the argument and getting a specific jury fact-finding as properly instructed?
I have a two-part answer for you, Justice Apple. The first part is, when we're looking at prejudice for not giving a jury instruction, was the defendant's rights injuriously affected, or was there a miscarriage of justice? And in this case, when we look at all the evidence as a whole, there's one witness who kind of assumes he was probably intoxicated, and then there's 4 witnesses who say he wasn't intoxicated, and there's a huge amount of specific intent evidence here. There's threats, there's statements to other witnesses, there's just the circumstances of the offense. He walks in, fires up to 9 shots at him. One witness hears him say, "I'm going to kill you." When we look at that evidence, did a miscarriage of justice happen? And under these facts, it didn't.
Are you relying upon more of a harmless error type of analysis? Because obviously, if it was appropriate to give the instruction and they didn't give the instruction, we presume prejudice unless the state comes forward and the record affirmatively establishes that there is no prejudice. So what's the evidence? Are you just saying there's so much overwhelming evidence to the contrary that there's no prejudice here?
That's correct, Your Honor, and that's a common ground for finding harmless error, is the overwhelming evidence of guilt. The second part of my answer to you, Justice Apple, was in this case, I think Mr. Cordero would have been in a worse position had the instruction been given. He was allowed to argue at closing arguments that the intoxication affected his specific intent. And I think the county attorney had grounds to ask the judge to exclude any argument on that topic at the closing argument, because it wasn't supported by the evidence. And if the instruction had been given and the jury had been instructed how to use the evidence, instead of having this vague conception of, well, yeah, he was drunk and maybe that affected his mind, they would have been instructed that the only time intoxication is a mitigating factor is if it completely eliminates his ability to form specific intent.
But was there an objection in closing argument to all of this testimony about intoxication?
There wasn't. And
so my question is, if we now have a ruling prior to closing arguments on the instructions which says I'm not going to give it because there's not substantial evidence, why then do you not object to that evidence, and why are you even allowed to argue it? Because there's nothing in the record to support the argument. Shouldn't the state have objected to it, just as you made reference to, and the court would have sustained it? They shouldn't have even heard any of this. So I'm a little troubled by the fact that you're not going to give this instruction on intoxication because you don't think there's substantial evidence in the record to support that argument, but then you allow defense counsel free rein to argue intoxication, and he does go specifically into the requirement that it has to affect his mental ability to form the specific intent. Why would you do that?
I agree, Your Honor, that if I had tried the case, I would have done it differently, and I would have objected to that evidence. However, as it stands now, the defendant was allowed to get into that defense, and he actually benefited from the lack of objection from the state. So,
Again, I disagree with the characterization that he benefited from not having the instruction, because to me, the court instructing on the intoxication defense gives it at least a validity from the court saying, well, there's at least some validity to this argument. That's for you, to the jury, to make this determination, but at least there's some evidence there of this intoxication, and by giving an instruction, it gives an air of authority that, oh my gosh, we really have to look at it, and here's the standard that we need to apply, and that's where I'm kind of troubled.
well, and I don't think we'll see eye to eye on that issue, but the fact that he did get to argue it, the fact that the instructions say, jury, you can apply your common sense when you're deciding the evidence here, I think it did give them room to consider the intoxication evidence, even though it wasn't warranted. So because the defendant did not present substantial evidence to support his defense, this court should affirm. Thanks.
Thank you, Mr. Hanson. Rebuttal?
Yes, Your Honor. I think the key here, and I think it's dangerous if we apply what the state is trying to argue here, is because the jury is instructed that they're only to follow the instructions that they're given. What they were not given here is how they were to use the intoxication defense. Yes, they're told that they're supposed to use common sense, but the court allowed this intoxication evidence into the record, allowed argument on this intoxication defense. The jury was left with no guidance on whether they can apply it to the specific intent or whether they cannot apply it to the specific intent. Because the jury's...
in fairness, there's probably two considerations. There's sort of the one that you're raising, Mr. Bender, which is it's helpful to have the instruction because it gives validity to the defense. On the other hand, there's the point that Mr. Hanson's making, which is it wouldn't have given as much validity to the defense as the defense attorney took at closing argument, that he, to some degree, got more free rein to argue what intoxication meant than the instruction would have given. So if you counterbalance those things, the question is, don't we have to decide in light of the entire record of this case, was your client prejudiced? Was there a miscarriage of justice? Do we need a new trial?
Well, there is a miscarriage of justice. You cannot allow intoxication evidence to come in the record, and then you can't, during jury instruction record, say, no, you can't have that instruction, and then allow the defense attorney to go out there and give that instruction, and the Court of Appeals latches onto that and says, you know what, that attorney, mirrors what the instruction was, but then you don't give the jurors who are ultimately determining the liberty of my client the ability to understand how to use that evidence. The jury is instructed that they're supposed to follow the specific instructions of the jury instructions. If you're allowing this, and intoxication was central to Mr. Cordero's defense at trial, and also the emotionally charged situation. And so therefore, if you're allowing that to come in, and you're not telling the jury how to use it, prejudice should be presumed. They didn't overcome the prejudice in this case. And also the fact that, the key here is not whether or not he was allowed to argue it or not in closing. The key here is whether there's a miscarriage of justice or whether my client's rights were prejudiced. And they were, because the jury was not given how to use that evidence. They were misled, they were confused, and this court has reversed countless times when jurors are misled or confused. I do want to go on to try to hit the other issues here real quick. With respect to the consecutive sentence, this idea of overall sentencing plan, I do think that the court needs to look at. The Court of Appeals relied on the fact that consecutive sentence in this case was due to the overall sentencing plan. I think the court's analysis, the Court of Appeals analysis in several cases that have came down recently to rely on that is insufficient. Here, the court did not give any reasons for consecutive sentence. Albeit these were mandatory sentence, we just don't throw away the rules and statutes just because they're mandatory. The court ordered consecutive sentence, went on and told my guy why he was a bad guy, why he needed to serve a lifetime in prison, but never connected the two. There was no linkage between consecutive sentence and the idea of incarceration. This court should really look at whether or not the overall sentencing plan language should be thrown out, and because the case that was relied on by Hennings and stuff, Judge Danielson in the Scott case I cited in my application talked about that there's not going to be one judge who says that their sentence is not part of the overall sentencing plan. So there are some serious concerns regarding that.
I was reversed in Henning, so, on that point, so I
Yeah.
leave it at.
Yeah, but I'm just telling you that we do feel that the rule with respect to consecutive sentence in this case was not met, and that albeit they were mandatory, that this court should reverse on that element as well. I don't have much time left, but with respect to the sufficiency, we do feel that all the intoxication that we talked about is the reason why there's not sufficient evidence. So therefore, I don't think we need to rehash that idea here. Any further questions?
Well, Mr. Benner, I know your voice is starting to weaken a little bit. I'm glad you've been able to hold on here, but let me just ask one quick question before you're done. On further review, on your application for further review, you did not bring up specifically the issue about ineffective assistance of counsel for failing to raise the defense prior to trial. Are you still asking us to review that issue on further review, or are you leaving that issue for another day?
Your Honor, I was, due to word count limit, I've only allowed so many words in my application for further review, so therefore I focused on the areas which I felt was necessary, but we would gratefully ask the court to review all issues that we raised previously, including ineffective claim. Right. Okay, thank you.
Thank you very much. The case is submitted, and the bailiff may adjourn court.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.